when any other person try to immigrate to America, they need sponsorship. They need somebody in America to fill up the form I-864. Its name is Affidavit of Support, to make sure that they can easily come to America. However, this sponsorship, while it is very generous, it is very good for immigrants. However, the person who is sponsoring this, uh, who is signing this affidavit of support form, who are sponsoring this immigrant, he or she is taking a huge responsibility, huge burden on them. It is always good. It is always good to help others, but you must know what responsibility you are taking when you're, signing the form I-864 for others. So today we are going to discuss what responsibility, what liability you are going to take when you sponsor others in family immigration and other kind of situation where you submit I-864. First of all, it is a contract. Many US forms, many forms that we submit to USCIS, these are not a contract. These are basically a immigration application or petition. However, form I-864, this is a contract, and the contract is between the sponsor and US government. So many people, they do not understand this, this dynamic of being signing a part of the contract. So, contract is a separate law. This is not a part of immigration law. The contract law depends on state. Every state has their own contract law. For example, New York, Texas, California has their own contract law. So if you live in New York and you sign the form I-864 on behalf of immigrant, not only you are going to follow all the immigration consequence of this I-864, at the same time, you are also you must abide by all the contract laws of that state. So that's why please remember that this is a contract between you and the US government. So I'm going to read it. In the contract known as Form I-864, the sponsor makes a commitment to the US government to support the intended immigrant if he or she is unable to do so now or in the future. So this is the sentence. The bottom line is this is a contract between the sponsor and US government. What responsibilities of a sponsor? So what responsibility and liability you're going to take over when you sign the form I-864? The sponsor, including the primary and secondary sponsors and the US government and parties to this agreement, as I said before, by agreeing to the terms of the contract, the sponsor guarantees that they will make enough money to support the immigrant. You make enough money to support the immigrant. The sponsor clearly states that his or her income is at least or above 120% of the poverty level by calculating their household size, including the intending immigrants. So, America publishes their poverty guideline every year. Right now, it is probably for a single person, 13,500 something kind of dollar. So if you are a single person and if you are going to sponsor another single person, then your household size would be 2. And for 2 person, the poverty guideline would be probably 16,000 or something. You can double check that in USCIS website. The name of the form that indicates the poverty guideline is called I-864P, P for PAM. So if you do not know the poverty guideline for 2 person, 3 person, 4 person, you can go to I-864P form in USCIS website and see what is the poverty guideline. So you are agreeing to make more than 120%, 125% of the poverty guideline, depending on the number of your household, including the intending immigrants. So you must understand these dynamics. The next one is the joint sponsor specifically promises that if the sponsored immigrant cannot make an income equal to or greater than 125% of the federal poverty level, she or he will support this immigrant. So this is a big deal. What it means is when you are sponsoring an immigrant to America, if the immigrant who just came to America, if he or she cannot make 125% or more of the poverty guideline, then you are going to support that person, not the US government. You are going to support that person. In most cases, US government do not enforce this clause. However, if they want, they can do it. That is the point of discussion for today's discussion. So the sponsor is obligated to reimburse the organization that supplied any means-tested public benefit that the immigrant received. So the meaning of this sentence is, a lot of time, when people live in America because of many, poverty, because of, sudden changes in their employment, or having like, pregnancy, or having baby, there's a lot of public benefit offered by American government. In general, it is called means-tested public benefit, meaning like it depends on the demand. A lot of time, a lot of state benefits are also mingled with public benefit. So federal benefits. So let's say the state of New York, they are offering some, week program, like in a SNAP program for, food stamp and other kind of benefits. Let's say 70% of the money come from state government and 30% of the money come from federal government. So even it was offered by state government, if there's any money from the federal government within any program, then you are subject to liable in those kind of benefits. Meaning, if the immigrant, if take any benefit from government, the agency who provided those benefits, they can sue you, or they can ask you to pay those money on behalf of the immigrants. In most cases, in general, US government do not enforce this clause, but if they want, they can do it. That's I'm going to tell you. All right, the last responsibility is a sponsor who is not a US citizen should inform the USCIS whenever he changes their addresses. A lot of time, especially when we have green card, we stop reporting our change of address to USCIS. That is not correct. The official rule is until you become US citizen, you must report USCIS about change of your address within 15 days of any changes, especially if you submit a form I-864 on behalf of other person, you must report your change of address to USCIS until you become US citizen. So those are the responsibilities. If you need more information about this, you can always reach out to us. I or anybody from our firm, we can help you. So duration of responsibilities. So this is a lot of people, they don't know this duration. A lot of the durations are very strict and very counterintuitive. So as soon as the sponsored immigrant has their green card, the sponsor is obligated to provide financial support. Only one of the following subsequent 5 terminating events can bring the obligation to an end. Meaning, as soon as the intending immigrant become a green card holder, then the obligation starts, and until one of these 5 things happens, you have to support these intended immigrants. Number 1, the sponsored immigrant becomes a US citizen. So meaning, when the intended immigrant, they become US citizen, your obligation ends, which is a good thing. However, in most cases, it takes 5 years. In some cases, it takes 3 years. In very few cases, it takes 6 months. In general, it takes 5 years to become a US citizen. So you are obligated to support that person for 5 years. Number 2, the sponsored immigrant has worked and can receive credit for all 40 quarters of coverage under the Social Security Act. I'm not going to go that detail into this thing, the Social Security Act, because this is kind of complex, and in most cases, most of the people, they don't qualify for this. So just for the information purpose, I kept it here. If you need more information about that, I can talk, one-to-one and can describe. Number 3 is the sponsored immigrant no longer has lawful permanent resident status and has departed the United States. Meaning, the immigrant whom you sponsored, he or she lost the green card and already left America. So once they lost the green card, your responsibility ends. The sponsored immigrant is subject to removal, but applies for and obtains in removing proceeding a new grant of adjustment of status based on a new affidavit of support if one is required. Meaning, he or she came to America with your sponsorship, and later, because of some reason, his sponsorship has been changed because of some reason. I'm not going that detail into removal proceeding and other thing. So as soon as your sponsorship ends and some other sponsorship starts, your responsibility ends. Number 5 is the sponsored immigrant dies. When the sponsored immigrant dies, your responsibility also ends. So these are very strict. In most cases, number 1 applies, which is when the sponsored immigrant become a citizen, then your sponsorship ends. Typically, it is 5 years. So here I'm going to tell you some situations, where you have to be careful about this I-864, because this is a contract between you and the US government. So every sponsor should keep in mind the following matters before signing the contract. When somebody agrees to financially sponsor a fiancé or spouse, they should keep in mind that the sponsorship obligation does not end with a divorce. This is very tricky. Even though you are divorced, until and unless your sponsored spouse become US citizen, you're obligated to support that person. And divorce law, family law is also another state law. So let's say your spouse lives in Texas, so all the rules and regulations of Texas family law will be applicable, including this sponsorship. Meaning, in general, if your spouse does not have enough money, you have to pay alimony, child support, property division, including all these things. This 864 will create another liability, and you have to pay additional money. The sponsor will still be liable to his her ex-spouse financially even after the divorce. This is situation number one. Number two, although the sponsor is not liable for the immigrant's personal debt and bills, he or she is usually responsible for making sure the sponsored immigrant have enough financial means to meet the US poverty line. So the short thing about this thing is, we all excuse me, we all have, like, credit card debt, home loan, car loan, utility bill like electric bill, gas bill, sewerage kind of bill. You are not personally liable for all those bills, but you have to make sure that this person meets the US poverty guideline. You have to make sure that part. If the immigrant sues the sponsor for financial support, the sponsor could be held guilty. As a matter of fact, the immigrant could decide to quit a job and sue the sponsor for support. Even the sponsor is responsible for the sponsored immigrant's legal fees and cost to enforce the I-864. Not only you will be liable for the support, you will also be liable for the legal fees to enforce this clause. So it creates a huge liability. That's why I made this. I'm talking about this thing today. A lot of people, they don't know what they're signing for. If the immigrant receives benefit from certain means-tested assistance program and the sponsor refuses to voluntarily refund the benefit, the US government may sue the sponsor to collect benefit program cost. Meaning, if the immigrant receives any kind of fund, and if the US government wants to get that money from you, the sponsor, if you do not voluntarily pay those things, US government can sue you. Again, US government in most cases do not enforce this clause, but they can if they want to. Next point is, if the sponsor is not a US citizen and fails to inform the USCIS about his/her address change, the USCIS may fine the sponsor in order to stop sponsors from evading their financial obligations to the immigrant. Again, if you do not report the change of your address, US government may fine you. The last point that I'm going to discuss today is, if the sponsor is obliged to file for bankruptcy because of financial insolvency, he or she cannot discharge their financial sponsorship duty. Therefore, bankruptcy may not be able to release him or her from this liability. This is another big deal. Meaning, like, a lot of time when somebody has, like, business loss or some other kind of situation, you have a lot of liability, you file bankruptcy, to get rid of all the liabilities. You may get rid of many other liabilities, but you will not get rid of this I-864 liabilities. So it will even survive after your bankruptcy. So this is a big deal.